All right, good morning, everybody.
Morning,
Good morning, Your Honor.
Back on the record and say the floor with Herbert Swilley, 23 CS 4461. I believe we have verified that the juror who was removed was Mark Cole. Is that correct?
Correct.
Does anyone want any additional verification of that?
No, Your Honor.
Okay. Normally what I do is the first thing I do when I'm getting ready to move the jury back is identify the alternates anyways. So if I call a name and another person gets up, let me know and I'll correct that. But otherwise, everyone is ready to go. Is that correct?
Yes, Your Honor.
All right. Mr. Swilley, you've been given an opportunity to call all the witnesses you want in this case. Is that correct?
Yes, sir.
There's no other additional witnesses you can think about that you haven't called?
Yes, sir.
Okay. You're satisfied with your attorney services to you thus far?
Yes, sir.
All right. So what we'll do is we'll bring the jurors in. I'll ask them the same few questions I typically ask them. Are you going to need? What do you need for closing?
Just access to the screen, Your Honor. That's all.
Okay. So many places we can put the podium these days, but you want the podium in the orientation it's at.
Yes, Judge, I don't need the podium. That's fine.
Yeah, it used to be we'd move it out of the way, but it's immovable. But if you want to point in one way or another, that's the sole extent of what I can do these days on a podium. It's wired to the floor. So I'll read up to, it's really not even very long. Go through the charges and then read closing argument. Okay. So, I mean, I don't think it has to be said because everyone's been very good in this case, but anyone in the audience, please do not say a thing during the trial. Everyone needs to remain quiet. I know everyone has done so far, and I appreciate that, but it's very important at this stage, we're at the very last stage of the trial. I don't want anyone to do or say anything that could throw us off. So I'm telling you now, if you say or do something during the trial, I'm going to stop the trial and conduct a hearing regarding contempt. So please do not say anything out loud or anything like that. Okay? So everyone's been very good so far, and I appreciate it. The parties appreciate it, but I don't want to blow it at the end. Okay? Let's bring the jurors in, please. Also, everyone make sure the phone is off or silent. Okay, thank you. Morning, everybody. As I always do before we go forward, I'm just going to ask by show of hands, has anyone said anything to you about this case? I see no hands and I appreciate it. Have any of you talked to anyone else about this case? I see no hands and I appreciate it. Has any of you gone online and looked up anything about this case? Again, I see no hands and I do appreciate it. As I explained to you yesterday, I'm going to read to you first the initial part of the instructions. All of what I give you, you're going to get copies of, but I ask you to pay close attention to it as I read it, okay? And then we're going to have the parties do their closing arguments, and then we'll give you the last instructions. I anticipate you will get the case sometime before lunch, okay? We have your lunch ordered. You're free to eat lunch and deliberate. You're free to eat lunch and then deliberate after. You do whatever you want to do. Once we put you in the deliberation room, it's up to you, okay? But if you can listen carefully to me. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Herbert Swilley, the defendant in this case, has been accused of the crime of first-degree murder. Homicide. In this case, Herbert Swilley is accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Timothy Smith was killed by Herbert Swilley, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the three following circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act, by lawful means, with usual ordinary caution, and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Herbert Swilley may be found guilty of first-degree murder or any lesser crime. Count 1, and this is the only count, murder, first degree. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1. Timothy Smith is dead. 2. The death was caused by the criminal act of Herbert Swilley. 3. There was a premeditated killing of Timothy Smith. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. Murder, second degree. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Timothy Smith is dead. 2. The death was caused by the criminal act of Herbert Swilley. 3. There was an unlawful killing of Timothy Smith by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Timothy Smith is dead. 2. Herbert Swilley intentionally committed an act or acts that caused the death of Timothy Smith. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intention to harm, then that violation, I'm going to reread that. Every person has a duty to act reasonably towards others. If there is a violation of that duty, without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death. Only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment, through each stage of the trial. Reread that. The presumption stays with the defendant as to each material allegation in the indictment, through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Both the state and the defendant have now rested their case. The attorneys now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Ms. Burnt, are you ready to proceed?
Yes, Your Honor. May it please the court? May I have access to the screen?
Yes. Right now, there's nothing plugged in. You're welcome.
Good morning, members of the jury. Before I start, I want to thank you for your time and attention this week. I know it's been a long week, and there's been quite a bit of evidence and a lot of witnesses, so thank you for that. This is Tim Smith. Tim was happy. He was successful. He was kind. He was involved in the community. And he was loved by everyone. Tim was everything that the defendant was not. And the defendant couldn't stand it. And when Tim decided he was finally going to leave the defendant and move to DeLand and get a new job, the defendant was so angry. He told everybody, if Tim thinks he's leaving me and moving, he's got another thing coming. He thought Tim owed him. He was not going to let Tim leave him that way. So instead, he brutally murdered him. This is a case about death by 1,000 cuts. And what that means is that there isn't one big piece of evidence or one big witness, but the accumulation of many seemingly small pieces of evidence, when put together, become devastating, and they result in the overwhelming proof of guilt. That's what this case is about. The defendant thought he was smarter than everyone. When Daryl Levine asked him, "Did you do this?" he didn't say no. He said, "No one is ever going to be able to prove it." But guess what? He hadn't met Sergeant Pinder and the other detectives from the Marion County Sheriff's Office, because they worked tirelessly for 8 months to prove this case. And remember all the things they told you they did. The detectives canvassed both neighborhoods where the apartment was and the residence was numerous times. They dug through the trash at those places. They knocked on every door and tried to collect every piece of video that they could. Other detectives went to every single business on the street between the apartment and the residence. They dug through the dumpsters there looking for evidence. And they got every single piece of video footage that they could. And then for the next several months, Sergeant Pinder reviewed all of that video footage. And think about how much video footage that was. I mean, they were asking for a span of 12 to 24 hours. He reviewed every piece of that until he found the defendant's truck and Tim's Jeep on that. So in the end, the defendant was wrong. We can prove it to you, and I'm going to show you that this morning. The defendant's charged, as you know, with one count of first-degree murder. And the judge read this to you, and this is in your jury instructions. This is what we have to prove to you before you can find the defendant guilty of first-degree murder. Now, you also heard in the jury instructions, there's what's called lesser included offenses. So even though this is what's charged, you will have two other options: second-degree murder and manslaughter. But the judge will tell you, you have to find the defendant guilty of the highest charge we have proven to you, which I submit to you is first-degree premeditated murder. The elements of second-degree murder and manslaughter are in your jury instructions. Second-degree murder would be if there was no premeditation, and the defendant and Tim just had a big fight, and the defendant killed him. Manslaughter is if the defendant didn't intend to kill Tim, but he did an act which killed Tim. Neither one of those apply to the facts in this case. And when you look at the elements of first-degree murder, you won't need to go any further to even look at the second-degree murder or the manslaughter. Now, as you see, there's three things, and that's it. These are the three things that we have to prove to you for you to find the defendant guilty. Number one, Timothy Smith is dead. There's no question there. That was stipulated to. That is Timothy Smith, and he is dead. The defense is stipulated to that. Number one is crossed off. That's proven beyond a reasonable doubt. And I want to skip to three, the premeditated killing of Tim. Was it premeditated? And I think a lot of people have the wrong conception of what premeditated means. This is the definition of killing with premeditation. It's killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. And what this means is there is no amount of time that has to be present. It doesn't have to be an hour before he decided he was going to kill Tim, the day before, or the week before. The only thing that has to happen for it to be premeditated is he decided he was going to kill him, and he had time to reflect on it and do it. That's what this says. There is no fixed exact period of time. That is what the law in Florida is, for you to find him guilty of premeditated murder. And I know we see a lot of shows on TV, and they make lists, they plan it for a while. And even though he did do that here, there is no set amount of time for premeditation. And how do we know it was premeditated? We have two different ways we know. One is the diphenhydramine. Tim did not take the diphenhydramine. The only way he got the diphenhydramine was from this guy right here. He had 30 times the amount of a normal dose of diphenhydramine in his system. We know he had a big interview the next day. There's no way he took that on his own. And he's the only person that could have given it to him. And the only reason that he would do that is so it would be easier for him to kill Tim, and Tim couldn't fight back. And that's why he did that. That's the only reason he would give him the diphenhydramine. And that clearly proves premeditation. But even if you don't think that he gave him the diphenhydramine, or you have questions about that, The manner in which he killed Tim proves premeditation. And that's because of a strangulation. That's a prolonged, tightening, squeezing, remember, until he broke his neck. When you are doing that, it takes some time. And Dr. Corey said that mark was so defined and dark that it had been on there a while. During that time when you are doing that and you are squeezing, you intend to kill Tim Smith. There's no way you don't intend to kill Tim Smith during the time it takes to strangle him. That is premeditation. Fits the exact definition of premeditation. And also, it's not just strangulation. We have two separate acts. He not only strangled him in the most horrific manner, he beat him in the face. I mean, multiple blows, multiple. You have the left eye, you have the right eye. I mean, during that time frame of beating him in the face, the time it takes to go get the ligature, whatever it was, maybe he had it next to him. He had to consciously pick that up, put it around Tim's neck, and then start squeezing it. There is no way you can say that he did not intend to kill Tim Smith and it wasn't premeditated. For both of those reasons. This is clearly a case of premeditated murder. He didn't just all of a sudden snap and say, oh, I'm going to kill Tim. And that's three. So now we've met one, Tim is dead, we've proven that beyond a reasonable doubt. Is it premeditated? Sure. You have two different ways it's premeditated. Pick which one. They both apply in this case. What does that leave? The death was caused by the criminal act of Herbert Swilley. That's the last thing we have to prove to you, is that this guy did it. I first want to talk about the defense witnesses before we go into our evidence. We heard from Amy Counts. She said she heard a child or a person screaming Friday night in the general direction of the apartment of Tim and the defendant's apartment, which is 3.5 blocks away. Thanks for the testimony, Ms. Counts, but Tim was already dead at that point. We know Tim was dead Friday evening, around 11 o'clock. Remember that there had been no use of his phone after 9:45 on Thursday. He didn't go to work, nobody had seen him, he didn't reply to a text, he didn't reply to a call. And by the time they found him Saturday, he had already started to decompose. So, Amy may have heard some screaming or a child screaming Friday night, but it didn't have a thing to do with this case. Not a thing. And it added nothing. Matt Beeler, I'm not really sure what he was called for. He said he flirted with Tim on Grindr the week he was killed, and then he found out Tim died. Okay. So that's fine, that's all true. That doesn't affect anything, the facts of this case, or make the defendant not guilty. Danielle Velez went out to smoke Thursday night around 9 p.m. The Jeep wasn't there. That's true. It wasn't there at the time, 9 o'clock, because it was at the house. She went to work Friday morning, and the Jeep was there. And she thought that was unusual because it usually wasn't there overnight. True, that's true, we proved that ourselves. The Jeep went there late Thursday night into Friday morning after 9, and then it was still there Friday morning because Tim was dead. So Danielle Velez helped prove our case and reinforce what we've already told you. Now we have Rebecca True. She was married to James True. He seems like a horrible individual, and I feel sorry for Rebecca True. But Rebecca True also helped prove our case that James True didn't do it because he was in Fort Lauderdale at the time, which we proved to you. How? James True. So if you remember, we heard a lot about DNA. James True's DNA was on an adult sex toy. And if you recall, also, defendants and Tim's DNA was both on that adult sex toy as well. The majority of the DNA on that sex toy was the defendant's. We don't know who had sex with James True at the apartment. That is unknown. All of their DNA was on the sex toy. They both used the apartment for sexual activity. And if you recall, in Deputy Hunt's body cam, the defendant told Deputy Hunt I was here last Saturday with someone. Tim did not want to play, so he went on a motorcycle ride. So the defendant was there 1 week prior. And that body cam is in evidence if you need to watch it. James True's fingerprint was also on the gun oil lubricant bottle in the bedroom. He was clearly there. He had sex with someone. But, what do we know? James True was in Fort Lauderdale where he lived from 5 p.m. on Thursday, March 23rd, until Friday, March 24th at 9:30 a.m. And their own witness, Rebecca True, helped prove what we already knew. She said, all I can say is I was in Marco Island when this happened. But the defendant sent her a selfie from their home in Fort Lauderdale at 5 p.m. on Thursday. And then the next morning, he sent her the video of himself playing with her son at their house in Fort Lauderdale. So we know those parameters right there. What was he doing in between there? So Rebecca True gave us those parameters. Well, now we look at his phone records, because guess what? When the detectives go down there and say, hey, James True, we need to talk to you. Your DNA was found at a crime scene. Can we look at your phone? Sure. Sergeant Pinder didn't need to get a search warrant for James True's phone because he said, here it is, and handed it right over to him. And then there at his house, if you recall, Sergeant Pinder downloaded the contents. And what do we know from James True's phone? He took a selfie in Fort Lauderdale. He liked to take selfies, clearly, on Thursday, March 23rd at 7:47. His phone shows at 7:47 he was in Fort Lauderdale taking a selfie. And then he took another photo of a tag, some sort of tag on a vehicle, at 11:05 in Fort Lauderdale. This is on his phone, 11:05. And his phone records show he received an instant message from Wells Fargo to verify a credit card charge at Blondie's Sports Bar at 12:54 a.m. At 12:54 a.m., he was at Blondie's Sports Bar doing whatever he did there. Blondie's is in Fort Lauderdale. Sergeant Pinder told you that. He personally knows that he's from Fort Lauderdale. That's a 4 and 5 hour drive to Marion County. Because we know he was back by 9:30 the next morning because he sent Rebecca the video. There's no way James True made it to Marion County, murdered Tim, and then made it back to Fort Lauderdale by 9:30 a.m. to send that video to Rebecca. He may be a despicable human being, but he did not murder Tim Smith. That's impossible with the evidence that we have shown to you. And all of this evidence is there for you to review. Lloyd Kelly. His DNA was on a lubricant bottle cap that was in the apartment. He testified by Zoom. He's in Virginia. He was meeting random people on Grindr for sexual activities with his wife. He doesn't even remember having sex with Tim or the defendant. He doesn't recognize the apartment. He said it's very common for people that he and his wife would meet at hotels to bring their own lubricant. And the defense attorney made a big deal about asking everybody, did you ever obtain a sample of Lloyd Kelly's DNA? Nobody went and swabbed his cheeks, but nobody's disputing that that was his DNA. They got the hit back from CODIS, which is a DNA database, that said it was Lloyd Kelly. And he's in there because he's a convicted felon and he's on probation. Got that. Nobody's disputing it. We don't need to go get another swab from him to prove it. It's his. Nobody's disputing. We're not disputing that. But unlike this guy, there's no reason in the world Lloyd Kelly had to kill Tim. There's been no evidence of a reason, no evidence that he even slept with Tim. We don't know. No reason. I mean, he was married, but his wife was participating in the sexual activity that he was doing with other people. There was not a lick of evidence or a reason Lloyd Kelly would want Tim dead. But there's 1,000 reasons he wants Tim dead. So we're going to move on to 2, which is the last thing we need to prove. Is there any evidence that Tim left that house on his own to go to the apartment to have sex with some unknown person? None. All the testimony's been Tim was in his PJs at 9:30 ready for bed. The defendant told every officer he saw that. Jordan says that. We know he had a big interview with Nina Corsi the next morning, a very important interview, one of the final interviews to get his job. There is no evidence on his cell phone going back several days, up to Thursday, that he would have any planned meeting with a person. There was nothing. Meet me at the apartment at this time. Let's hook up at this time. There was nothing on his phone talking about meeting anybody at the apartment. There's no user activity on Tim's phone after 9:45 p.m. Nothing. Because at 9:30, he's ready to go to bed, and there's nothing after 9:45. The diphenhydramine level, we can't get around that. I mean, he most likely was not even awake, let alone conscious. There's no way that guy was driving to the apartment to have sex with somebody. He couldn't drive, let alone have sex with somebody with that level of diphenhydramine in his system. There is no way. And also, he didn't take his erectile dysfunction medication, which is tadalafil. And if you recall, the tadalafil was found in the apartment. His name's on it, and he's supposed to take it when he needs it. I asked Dr. Corey about that. When you got the blood results back, did the blood results check for tadalafil? Yes, they did. They screened for that medication. Was that in his system? No, it was not. Certainly he would have taken that if he was going to meet somebody at the apartment. The diphenhydramine surely was in there, but the tadalafil was not. So we know that there is not a shred of evidence that he was going to leave that house and go to the apartment. None. That is all speculation and conjecture on the part of the defense. The marriage was over. I think we've proven that beyond a reasonable doubt. It started deteriorating in 2019 when they joined AA. Jordan said they stopped drinking, they started arguing. And going back a year before the murder in May of 2022, Diane DeLucy, she hired the defendant to do some work at her house, and he was there a couple times. And she said he was very angry with Tim. And he yelled and screamed while he was there, yelling, "Tim owes me," and Tim is a lazy SOB. And she demonstrated for you how he said those things about Tim. This is just about a year before Tim was murdered. That's when things started their downhill spiral. And in the months leading up to the murder, Jordan would go to work early. She was working at Laurito's Italian restaurant. She would go early just to get away from all of the fighting that was happening in her house. But by March of 2023, we know things were really, really bad. And you heard from Jessica Hendricks and Michael Horton. And they were friends with both Tim and the defendant. These aren't any people that were like, oh, we were best friends with Tim and we didn't like the defendant. They were friends with both of them. And they said about a month before Tim was killed, they hired the defendant to put in a sink, like a salon sink at their house, and it took a long time, about 6 or 7 hours. And all he did for almost the majority of that time is complain about Tim and their relationship. They described him as being frustrated, angry, and defensive. And remember, they weren't asking him questions. I said, are you asking about the relationship? They were not asking questions. That's a long time. Think about how long that was, how mad he must have been to spend so many hours venting about Tim. He told Jessica there were problems in the relationship and they were breaking up. He told Jessica that Tim can't take anything from him. He's a hardworking man and he supported the family, which we know is not true. You have all the financial records which are in evidence. And the defendant told Jessica if he had to do it all over again, he wouldn't marry a man. It was done. He was mad. He told Michael about Tim's new job. He was not happy about that either. He told Michael Horton they were fighting a lot and they were probably going to split up. And the demeanor that everybody describes is angry and mad. And if you recall, Michael Horton tried to console the defendant because they were friends. So he's got no reason to make any of this up. I said, what did you say to the defendant when he was complaining? I tried to console him because we were friends. We've got no reason to come in here and make any of these things up. Now, we did put some hospital records and evidence, which I'm going to show you, but Jessica and Michael were about a month before Tim was killed. Now we move on to Sunday, March 19th of 2023. This is 4 days before the murder. Tim was in the hospital. The defendant went to brunch with their group of friends from AA. And he sat next to Daryl Levine. And he started telling Daryl that Tim was getting another job, and he was very unhappy about it. And he told Daryl, if Tim thinks he's going to get another job and leave me with nothing, he's got another thing coming. Did that happen? Did he say that? Yes. And we also know because Kevin Branch heard it. He was at the brunch and you heard him say it. And if you recall, he said, the defendant wasn't even talking to me. But because of the intensity with which he was saying these things, I turned to look. So imagine, you're at a big brunch. The intensity with which the defendant was complaining about Tim was so strong that Kevin turned and looked. And he heard him say, if Tim thinks he's leaving me and taking another job somewhere else, he's got another thing coming. And then the defendant also told Daryl, which really bothered Daryl, Jordan and I loved Tim. We really did. In the past tense. All of these witnesses and all this testimony confirms there's no question this marriage was over. And think about this new job. You heard a lot about that and you probably wonder why. Well, think about that he was willing to leave a job he had been at for 7 or 8 years. He loved that job. Everybody loved him there. This was not a big pay raise. He wasn't getting a big pay raise. Nina Corsi said, look, he was making more than we were willing to pay, but I was going to get the management, the owners, to come up to what his salary was because she wanted him so bad. So he wasn't getting a pay raise, and he was going to have to relocate. He was going to have to leave all of his close friends, and you've heard about the close group of friends that he had. And think about this, he was also going to have to leave Jordan. I mean, Jordan was like a daughter to him. He and the defendant had been together since she was 8 years old. How bad were things with the defendant that Tim was going to give up everything he had and loved in Ocala to get away from this guy? He was going to give it all up for no more money and to leave everything. And we know he definitely wanted the job because Nina Corsi said, well, she was surprised too that he wanted to leave Brookdale. She was surprised. Tim said he was very excited for a new opportunity and change. That's what he said. The last thing that Tim emailed Nina Corsi, she testified, was, can't wait to talk to you, looking forward to it, at 9:43 on Thursday, March 23rd. That final interview was Friday at 9 a.m. And you know he was going to get the job because Nina said, I told the owners, this guy's great, he's very professional, we need to make him an offer. And she said when she recommended someone to the owners, they always went with what she said. But think about how bad things were that he was going to give up everything he loved to get away from this guy. And how would a divorce affect the defendant? Well, we know because he told everybody how financially destitute he would be without Tim's salary. He told everybody, after Tim died, I need the life insurance money, I'm struggling financially. There's no question that he could not afford to live the way he was without Tim's salary. The day after they found Tim's body, Candace Baker went over to the house. And she said the defendant was already in the office looking for the insurance papers. And he told her, I need my money. The day after they found Tim's body. Why? Because that's why he did it, so he would have the life insurance money. He told Jordan multiple times he needed the insurance money to pay the bills. He told Victor Gardner multiple times he was struggling financially. He told Daryl Levine he was having a hard time getting the insurance money and he needed it. He told everybody that. That was no secret. And he talked about getting the insurance settlement and that he was going to take a big trip in an RV to the mountains once he got his money. Now, Deputy Kyle Shaw is the first well-being deputy. He did that check on Friday, March 24th. And if you recall, the defendant did everything he could to make sure that that deputy had no reason to make forced entry into the apartment. everything he could. Deputy described the situation as nothing urgent, nothing to cause alarm or suspicion. He said the defendant made it seem like it was not that big of a deal. The defendant told Deputy Shaw, "Oh, Tim meets clients here, and then he leaves in their car all the time. No worries." Based on what the deputy saw and the defendant's lack of concern, lack of urgency, there was no exigent circumstances, and Deputy Shaw could not break into the apartment. And the defendant told Sergeant Pinder that Deputy Shaw told him to go check the hospitals to see maybe Tim's there. Which is interesting, because guess what? The 2 weekends before the defendant murdered Tim was in the hospital. This is March 11th of 2023. This is 2 weekends before. Tim goes to the hospital because he was complaining of waking up in the morning, trying to get out of bed, and then passing out and falling on the floor. He woke up, he was weak, and he was unable to get to the bed. Once he was helped to the bed, he was seen double vision, and he again passed out. 2 weekends before, Tim's at the hospital. He doesn't stay that day, although the hospital records are in evidence. He checks himself out. They do a bunch of tests. They're like, "We don't know what's wrong," and he leaves. But guess what? He goes back the following weekend. And this is the Saturday before he's murdered, March 18th. He goes back to the hospital again. Same thing. He says, complains of weakness, difficulty getting his words out, and it began at 00:30, which would be 12:30 in the morning, when he woke out of his sleep. He attempted to ambulate to walk to the bathroom. When he became weak, he had difficulty getting out of bed and difficulty getting his words out. He had to spend the night in the hospital. This is Saturday. He spent the night at the hospital and got discharged on Sunday. This is the Sunday that the defendant was at La Cuisine having brunch, while his husband was in the hospital for the second weekend in a row. And these are the things. He's passing out. He's dizzy. He can't get his words out. This is the weekend before his body's found. Knowing that, how do you not tell the deputy that when he comes there on Friday when you call him? You don't tell the deputy? "Oh my God, my husband has been in the hospital the past 2 weekends. He's been passing out, he's weak, he can't talk. We don't know what's wrong with him." You don't tell the deputy that? It's because you don't want the deputy to go in there, and you already know that, you know Tim's dead in there.
Excuse me. I'll push for a second.
What is the normal response for someone whose spouse had just gotten out of the hospital? What is a person's normal response? Kick in the door? Is Tim passed out in the apartment? His Jeep's here. He's passed out the past 2 weekends. He hasn't even been able to get to the bed. A person's normal response would be to break in the door. He was a handyman. He put that door on. He could fix the door. His excuse is, "I didn't want to get arrested, so I didn't kick in the door." Okay. He didn't do that. He didn't do any of that because he knew Tim was already dead in there. Even if he didn't want to kick in the door, he would have certainly told the deputy. And the only reason he didn't do any of that is because he knew Tim was already in there dead. Because if he didn't know that, he would have forced entry into the apartment or certainly told the deputy, because then the deputy would have been able to go in there under exigent circumstances. And even further, when he finally gets Jack, the landlord, to meet him at the apartment with the key, he still doesn't go in. If you recall the body cam, the deputy comes up and he's standing against the car with Jack, the landlord. Jack was asked, why didn't you guys go in if you were both there with the key? And Jack, the landlord, said he didn't want to go in. I don't know why we waited for the deputy. I mean, his whole thing is, I don't have a key, I don't have a key, I can't get in. Well, when you finally get the key, and you're standing there with the landlord, why don't you go in then? And he had been there the weekend before, on his own without Tim. The landlord is there. There's no reason not to go in. The only reason is because he knows Tim's already dead in there. He's got a key, and he's just kicking back with Jack, waiting for the cops to get there. There's no other reason he didn't go in there with the key. And these are, you heard about the text messages that the defendant sent to Tim over Thursday night and Friday and Saturday. And these are just two that I put up here from Saturday. And the first one's at 5:48 in the morning. The defendant is trying to cover his tracks. He's got to make it look like I'm looking for Tim. He says, hey, Tim, still haven't heard from you. Spent all night, still worried. Please give me a call if you get a chance. Love you. Of course, no response. Then at 6:06, hey, babe, I have no idea where you're at. What's going on? I'm heading to work in the Villages. Please give me a call. Is this a realistic text that you're going to send your husband who hasn't contacted you, hasn't called you, hasn't texted you? You've got the police involved. If you didn't kill him and you're really worried about where he is you just going to be like, hey, babe, I don't know where you are? Or are you going to be like, call me right now. I've called the cops. Where are you? This
I'm going to object to golden rule again.
That's sustained.
And I would move for a mistrial at this point.
Then, Jim, I'm going to ask you to step out just for a few moments with the bailiff. All right, sir, the jury is out of the courtroom. You had an objection. I sustained the objection. Is there anything further you want the court to consider?
Yes, I would ask the court, I would move the court for a mistrial. The state initially crossed that line in the golden rule territory. The court caught it. It admonished the parties. And now it has happened yet again. The only recourse, I don't believe a curative instruction is enough to overcome what has occurred. For a golden rule, the remedy is a mistrial. So I am moving for a mistrial at this point, and would ask the court to grant the motion.
Ms. Byrne?
Judge, after we discussed it at the bench, I said a person the next several times. That was the first time, if I said you, that I said it after a person. I clearly said a person all the times after that.
All right. First of all, I don't find there was a true golden rule violation, which is when an attorney is trying to put the juror in the place of the defendant or the victim in order to gain sympathy, in order to, generate some sort of empathy, anger, anything else along those lines, because that's not appropriate for the jury to consider. I noticed Ms. Byrne saying you. As I told you guys when I called you up, I just said, hey, let's kind of be careful about this, because my opinion, and what I said when you guys came up here, in case the record wasn't clear, is that I believe she's using you in kind of the omniscient, like not you as a juror, just like you as in, the omniscient, the world in general. She was using it to describe how generally a person might feel or do, and then comparing that to what the defendant did. I find that I believe in this situation, and what I find is that there's no intention to put the jurors in the place, or make the jurors feel like they're in the place of the defendant or the victim or anyone else, is simply a manner of speaking, a way of describing events, a way of describing actions, a way of describing thoughts. Like I said, I don't think that it was a golden rule violation. I just ask you to be careful because sometimes people might interpret it as that. Because, for example, if you said, Juror A, how would you feel if someone came behind you and strangled you? That would be a golden rule violation. Here, I think, like I said, it wasn't being used to particularly have a juror be placed in the position of victim or defendant, just kind of used in the omniscient. And then instead of saying, how would a person feel, she said, how would you feel? There's really very little difference in that, and it's really just a manner of speaking. So I'm going to deny the motion for mistrial for those reasons. But again, caution you that, and it may just be the way you communicate. We all communicate differently, you know, but we do have to be careful to instead of saying the word you, saying, how would, I mean, you know, a rational person or
Yes,
anything like that. And I understand this is a closing argument. It's when any person is making an argument in front of a tribunal, you got to think about what you're saying, you got to think about the facts, you got to think about the law. You're not always really careful enough to make sure that you speak in this perfectly neutral manner. You kind of just use your regular way you might communicate with somebody. And that's what I think is happening here. Again, I don't find there's an actual intention to make the jurors feel empathy, sympathy, or be in the place of the victim here. That would be problematic. Like I said, and I think I described the differences between the two. But it is a court of law, so I ask everyone to be careful about how we phrase things. But I'll deny the motion for mistrial at this time. Do you want me to give a curative instructions or not, Mr. Klein?
No, Your Honor, I don't believe a curative instruction would be appropriate. I believe the only remedy is a mistrial, and I respect the court's ruling in that regard.
Okay, thank you. All right, so with that, we'll bring the jurors back. Thank you. Welcome back, ladies and gentlemen. We're ready to begin. Go ahead, Ms. Burr.
Thank you. As I was saying, these are the two texts that the defendant sent to Tim the morning that his body was found on March 25th. All of the defendant's actions show he did not care that Tim was dead. What did he do after they found Tim's body? He wasn't upset at all when Deputy Hunt's body came, which you saw. When he said, deputy came out, the defendant asked, is he in there? The deputy said yes. The defendant said, is he okay? The deputy said no, and he just went. He never asked, what happened? Was he murdered? Did he commit suicide? Can I go see his body? Didn't ask any of those things. Just said, whew. And then when Deputy Hunt said, I'm going to call major crimes, he didn't ask, was he murdered? Why would you call major crimes? What happened to him? Was he shot? Was he stabbed? Doesn't ask any of those questions. And Sergeant Pinder talked to the defendant right after they found the body in his car. And he said the defendant was pleasant and calm. Nobody that talked to the defendant Saturday when Tim's body was found, or any of the days after that, said the defendant was upset. Nobody. They all described him as normal. And the defendant, this is Sunday when Candace Baker talked about this. Sunday after they find the body, the defendant is throwing all of Tim's things away. Everything. Clothes, knickknacks, food, vitamins. Professionally taken photographs that were hanging on the wall. The defendant took them down and had a stack on the table. Everything. It was a fire sale. Get rid of it all. Why? Because he didn't care. He killed him, he got rid of him, and we're moving on. And he told Candace. Candace was very upset. And he said it was his house and he could finally have it the way he wanted. Are these the actions and the things of a man who's upset? That his husband, that he's been with for 15 years, is dead? And the next morning, early in the morning after they find Tim's body, he's on Grindr, the dating application where they meet men to have sex with them. The following morning, 2 people saw him on that, not just one. And he took all of Tim's books and journals and a strip of photographs and donated them to Soul Essentials. And that was 5 days after they found Tim's body. And Darrell Levine said the defendant was at a gay campground the weekend after Tim's body was found. He said it could have been the weekend after, 1 to 2 weekends after Tim's body was found. The defendant was happy and having a great time by the pool. That's what he was doing. And then he moved his friend Kevin into the house and was sleeping with him in the bed he shared with Tim. Victor Gardner told you that Kevin had moved into the house, and Jordan told you they were sleeping in the same bed. This is the picture strip that the defendant got rid of when he donated all of Tim's things. And this is Tim's journal. And you can see from these pictures, they appear to be younger. They appear to be very happy in these pictures. And this is Tim's journal, where he's written things about himself. Hugger, comforter, compassionate leader, good listener. The defendant got rid of those things. If he loved Tim and was upset that Tim had been murdered, these are pictures of a happy time with Tim, where Tim wrote words that described himself. If he cared about Tim and hadn't murdered Tim, he would keep this forever. This is a big thing he got rid of 5 days after. Now, besides all of those things, and all of the testimony from everybody that said they were fighting, he hated Tim, he said he wasn't going to let him leave without him, he needed the money, and the insurance records are in evidence, you can look at those, and there's the 401k as well as the $333 of life insurance. There was a retirement policy, and that's in evidence for $48,000, and he was the beneficiary of all of those, and we know how badly he needed the money. But on top of all of those things that I just went over with you, we had the video proof. Now remember that the defendant told everyone he was home all night sleeping. Everybody he talked to, from friends to first arriving deputies to Sergeant Pinder. He told Deputy Hunt in that body cam he takes sleeping pills and was asleep all night Thursday night. He told Sergeant Pinder he took melatonin and he sleeps hard. That's his quote. The videos prove he was not sleeping all night. And I tried to condense these and make these as easy to follow as I could. I know you heard a lot about different times and videos. The first thing that happens is the defendant driving his truck to the apartment after he murders Tim. And I want to go over this map that I know you saw a lot of quickly. Right here is where Tim and the defendant live. This is Pedro Vasquez's residence, where we have a lot of video from. Down here, this is not a road. There's one house that's down here with one person that lives here. So if the defendant is going to leave his house, he either comes out the front way and has to come up this road to get to 52nd, or he can come out the back of his house this way and come out here. So those are the only two ways in and out, are this way or this way, right here. And Pedro Vasquez had cameras at both of those places. So when the defendant was supposedly sleeping hard, we have his truck leaving the residence. And the first time we have it leaving, it's coming out this way. So it comes out this way, it goes here, passes the Vasquez cameras, and goes up. This is a picture of the defendant's truck, and we talked a lot about it was distinctive because it looks like the tailgate's down in this picture, but it's not. The tailgate is up, and the whole truck is white, and this tailgate is black. Now this is Friday, early morning, 1:59 a.m., when the defendant was supposedly sleeping. This is the same time that Tim's phone leaves the house and moves towards the apartment. Tim's phone is moving, Tim's body is in there, and the black bag is in there, and this is the defendant's truck, and this is from the video. It's just stopped. The video stopped right here. This is him passing the Vasquez house, going up the road right there. And he's the only one that had a white truck like that, and leaving at 1:59, the same time. You can see the picture, clear as day. And this is the other one. If you remember, the Vasquez had two camera angles that were going on that road. This is the other camera angle. Here we go, we're leaving. 1:59 a.m., same time Tim's phone's moving. Here's his truck. And we passed by some more things. I know you've probably heard more than you ever want to hear about these places. Green for Life. This truck passing by here. And this time is approximately 2 a.m. And if you recall, the time was off on the Green for Life camera. And we made sure that we had the person who actually got the video and worked at the store talk to you about whether the time was off. Plus the deputy that collected the video also told you whether the time was off. And they both testified that this would be approximately 2 in the morning. So he leaves his house around 1:59. He's passing Green for Life at 2 a.m. Now this right here, as you can see, is the true green right here. Triple crowns. He's passing at 2:02 on Friday. Triple crown. And this is his truck going by right underneath the red. And now the Marathon gas station, 2:02. And they said that they're right by each other, so it would be about the same time he'd be passing the Marathon and the Triple Crown. Here you go. That's his truck. So you have him clearly leaving, passing by Pedro Vasquez's, passing by those three businesses, exactly the time he would be passing them to go to the apartment. So he gets to the apartment, and then he's got to come back home, because now we got to get Tim's Jeep. So now he drives the truck back to the apartment. He's put Tim's body and Tim's phone in the black bag in the apartment, and he's there about 20 minutes. And now he's coming back. And this is the Marathon. There's the truck right here, 2:23. He's there about 20 minutes. Here's his truck going the other way, heading back towards the residence, right here. Triple Crown, 2:25. Right here is his truck, heading back to the residence. And there's no video of him coming back from the Green for Life, because if you recall, the deputy said that for some reason skipped ahead a few minutes, so the time that he would be passing by there wasn't on the video. That's why there's no Green for Life. So he gets home. And this is him passing by Pedro Vasquez, coming back home. Right here. This is 2:27. As you recall, he lives right down here. And he's got a fence. And you're going to see him turn right into his house. it comes. Coming right by. And we know that that's his house, the direction he's going. Because that's the only thing back there. Now what is he going to do? Now he's got to get Tim's Jeep to the apartment. And this now is 2:40 in the morning. So he's gone home, he's been there for a couple minutes, now he's doing Tim's Jeep. Got to get that there. And again, this is coming right from his house. There's nothing else down here. That's coming from his house. Tim's Jeep moving out now. $240. Now, we have the Jeep's going to be taking the exact same path that the truck took. 241, passing green for life. Tim's Jeep. Going by the Triple Crown, 203. I'm sorry, 243. The correct time because the video camera was off. And this right here is the Jeep going by at 243. There's the Jeep right here. You can clearly see it. This is the Marathon. 243, because those are right by each other, so the time's the same. This is clearly Tim's Jeep. 243, going to the apartment. And now you heard that Tim's phone was found in the toolbox in the apartment. That toolbox is right by a window that faces the parking lot. So when the Jeep pulls up to the apartment, it connects with Tim's phone because he has the Bluetooth. So Tim's phone is there right by the window in that toolbox, and when the Jeep pulls up, they connect. And here's the report that's in evidence. And this is at 2:44. We know the Jeep connects with Tim's phone. That's when the Jeep is pulling up. And again, this is in evidence. This right here is from 6:45 because that's when he got home Thursday on the 23rd. He came home and disconnected from the Jeep. Now here you are right here, 3:24, 2:44, connected, and then disconnected. 2:44, the Jeep pulls up and connects with Tim's phone, which is in the apartment. There's more evidence, and all of these things just confirm all the video. But we have the other video, and I call it the cat video, because the cat's the one that set it off, if you recall. And what do we know about that? This is very small, I wrote it bigger here, it's on the bottom, it says 2:32 right here is the time. This is from Stuart Mitchell. He's funny, he said, I was nosy, so I looked out to see what was happening. So this is his apartment, and he has his camera that faces right here. If you look at the bottom here, you can see the cat that sets it off when I start playing it. A cat walks by and sets it off. And as you can see, at 2:32, the Jeep is not there. This is where we're looking. This is where the Jeep eventually ends up. The Jeep is not there. There's the cat right there on the bottom. No Jeep, 2:32. Now, we're at 3:26, and you know that because you can see in the bottom, it's very small, 3:26. The cat sets it off again, you'll see the cat. Here's the Jeep. The Jeep is there, and the Jeep was not there before. Because you know the Jeep got there at 2:44 because that's when it connected to Tim's phone. And clearly, if the Jeep does not set off the motion activation on this camera, then if the defendant parked on the other side of the Jeep to go into the apartment, it's not going to set that off either. That's common sense. So the Jeep didn't set it off, a truck parked on the other side is not going to set it off at all. You can see the cat right there on the bottom, set it off, and now Tim's Jeep is there. So we know it wasn't there before, and it's there now, and all of this evidence just corroborates everything that we have. Because we know it got there on 244, it was there. Now the defendant has to walk back home, because he's left the Jeep. And Detective Pinder had to look through a lot of video, but he found him walking. And I put a red circle around so you can follow. I know it's hard to follow. This is the path that he's walking. Starts here. Walking, walking, walking. This is at 251. This is from the Maricon gas station. Now, you'll see when the red circle starts and it follows. But if you watch, you can see when he walks by somewhere where there's a light. Like right here, it will go dark when he walks by. And then when he gets right here, you can see him walking through. And especially right here, you can see the body walking. Look right here because you'll be able to see when he walks by there. Walking right by there, and you'll see it again right here. He's moving. He's got to get home. Again, crosses right by. You can see when the light right there goes off when he walks by. According to Google Maps, which again are in evidence, it would take 35 minutes for the defendant to get from that spot at the Maricon gas station back to his house walking. That would put him at his house at 3:26 a.m. He is accessing that Ring doorbell camera at 3:26 a.m. Can't get around that. The phone records are in evidence. When he was sleeping hard after he took his melatonin, he somehow is accessing the Ring doorbell at 3:26, the time he would get home after that walk. And then after that, he's on Facebook, Grindr, and Gmail until he leaves to go to the gym. Jordan Swilley. In a case of a death by 1,000 cuts, this is the final cut. Right here, Jordan Swilley. She's obviously in a terrible position. She loves her dad. She loves Tim, who's like a second father to her. She said she got woken up because she heard a noise. She doesn't know what kind of noise, but the noise woke her up. Her Ring doorbell app was going off after the noise multiple times, she said. She didn't check it, but it went off multiple times. And the next morning, the defendant asked her if she heard anything. She said yes. And the defendant said, "You were sleeping. That's all you need to remember." I asked her, "Did the defendant ask you to lie for him?" She said yes. He told her, if anyone asks, I was home all night. But we know he wasn't home all night. She was upset. She was confused. She went to her best friend Layla's house to talk to her about what she heard that night before and what her dad had told her. And then she even had to go to see her friend Allison just to get a hug. She was so upset. Tim was gone. She didn't know where he was, and her dad was telling her to lie for him. Probably one of the most important pieces of evidence that she said is that Friday night after they went to the apartment, her dad made her stop at a gas station so he could throw away a pill bottle because he didn't want to throw them away at home. That was the alternative. He didn't want to get home. This case has clearly been proven to you beyond every reasonable doubt. We would ask that you find the defendant, Herbert Swilley, guilty of first-degree murder. Thank you.
Thank you very much. Mr. Clowney, you ready to begin?
Ready, Judge.
colleague, my client, and I are grateful for each of your time and attention during the course of this lengthy trial. And the best news is that it's coming to an end, right? So thank you for your time. I know it's a sacrifice. Watched some video evidence a few moments ago. We know who's driving those vehicles. Sure, you see vehicles that appear to be a white truck and the white Jeep that belonged to the victim. And appears to be the white work truck that belonged to Herbert, my client. But we don't know who was driving those vehicles. We see something walking by the Marathon gas station. We don't know who that person is. State wants everything to fit neatly into their timeline because that's their theory of this case. But that's just what it is. It's a theory. They have video evidence to support that theory. But what evidence do they have that was presented that supports the theory that Tim Smith was murdered at the marital home and his body was then moved in Herbert's white work truck to the apartment and staged? Did Sergeant Pender, who was a detective for a majority of his time in this case before he got promoted to his current position, did Detective Pender ever take the time to process that white truck for blood, prints, DNA? No, he didn't. Did Detective Pender ever take the time to have his crime scene forensic technicians process that white truck? No, he didn't. Did he take the time to have his crime scene technicians process the marital home for these items? No, he didn't. I will say, though, that the Marion County Sheriff's Office did a thorough processing of that apartment. They were there from the time that the body was discovered in the late morning until the late evening that night, almost midnight that night. So 12 hours, give or take. They were there collecting evidence, taking pictures, processing the crime scene thoroughly. And what did that processing reveal over the course of time? It revealed latent prints of value. It revealed DNA evidence of value. And these latent prints of value and DNA of value were linked to known criminal offenders in law enforcement databases, whose names were not Herbert, but instead James True and Lloyd Kelly. And the state wants you to believe that James True it's impossible for him to have committed this crime because it doesn't neatly fit into their timeline. Their theory of the case. You heard from the medical examiner very experienced lady who said that the time of death is determined from the last time that person is known to be alive until the time that their body is discovered and they're deceased. That date range in this case is from Thursday, March 23rd, 2023. 9:30 p.m. was the last time Tim Smith was seen alive by Jordan, up until Saturday morning, March 25th, 2023. So we have a span of 2 days. And the last time that Rebecca True knew of James True's whereabouts was 9:30 a.m. Friday morning, March 24th. She doesn't know where he was or what he was doing after that. And remember when Sergeant Pender testified the first time around, he said that he had used the license plate reader system to do a search on what he believed to be James True's vehicle, the Cadillac Escalade. And he couldn't find anything on those license plate reader results which would indicate that James True, that vehicle anyway, was in Ocala during the date ranges of Tim Smith's time of death in this case. But according to Rebecca True, that Cadillac Escalade had a breathalyzer in it. And James True is an alcoholic. So when her Volvo SUV was available to him, it would not be uncommon for him to use that vehicle instead. But Sergeant Pender said he didn't even know James True was married. He couldn't remember what other vehicles were there at their home in Parkland when he went there to visit. He was searching for the wrong car. And what about Lloyd Kelly? We heard from Lloyd Kelly. He testified. He's a multi-convicted felon, that he's currently on felony probation, that he and his wife would meet people on Grindr and have sexual encounters with them. He didn't recall Tim Smith, but the evidence is what the evidence is. And his DNA, Lloyd Kelly's DNA, was on that gun oil lubrication bottle that was discovered in the same room where Tim Smith's body was found, in that apartment. Initially, Herbert Swilley was cooperative with the investigation of Tim Smith's death. He had contacted Marion County Sheriff's Office to do wellness checks on Tim Smith. Ultimately, Herbert obtained a key from Jack, the landlord, which was provided to Deputy Hunt, who made entry into the apartment and discovered Tim Smith's body. And we saw the body camera from Deputy Hunt, so we know exactly what he saw. And the state wants you to believe that Herbert had no reaction on that body camera. But if you watch the body camera, if you need to see it again, it'll be available for you all to review as many times as you want. Everyone grieves in their own way. And at this point in time, Tim had been missing for a few days. It was unlike Tim to not show up for work. That was just not Tim. Herbert very well could have known there was a problem given that. So it was not entirely surprising to him that no one was answering the door, that Tim was not responding to text messages, and that Tim was not okay. And speaking of that cooperation that Herbert initially provided to law enforcement, he did the walkthrough of the apartment with Detective Pender after Tim Smith's body had been removed on the day he was discovered. And he pointed out some things that were rather important, because Herbert used that apartment too. He had just been there the weekend before. And Herbert pointed out that the gun oil lubricant bottle was not in the place where it was supposed to be. It was discovered in the room that had a bed in it where Tim Smith's body was. But it was supposed to be in the neighboring room that had the massage table, the toolbox, and the adult wing. But it wasn't there, and Herbert pointed that out. And lo and behold, that item had two different known offenders, either print or DNA on it. James True and Lloyd Kelly. He also pointed out that there should be no bleach. Tim Smith doesn't use bleach, gives him a headache. They don't keep bleach in the apartment. And he pointed out that there were some towels that were missing. Herbert allowed the sheriff's office access to Tim's white Jeep, which was still parked outside in the parking lot. They took pictures of it, and then they released it to Herbert. Herbert allowed Detective Pender to look at his phone, to look at the ring application. But Herbert was damned if he did and damned if he didn't. And I say that because look at what his cooperation did. Detective Pender claims he looks at Herbert's phone, he goes on to the ring application, and he finds these still images of what he later determines, even though he's not a ring expert, determines were deleted videos. And that's an important piece of evidence, if it truly ever existed, because it's the only thing that definitively would prove that Herbert was not inside the marital home asleep on the morning that the state claims, according to their timeline, this murder and body move took place. Yes, you have the vehicles on video. Yes, you have a stick figure walking by a Marathon gas station, but you cannot identify who's driving those vehicles or who that stick figure is. Herbert is damned if he doesn't. He gets concerned. He gets a lawyer. He takes the Jeep, instead of taking it to an appointment with Detective Pender, he takes it to his lawyer's office, Gail Grossman at the time. And Gail ultimately, voluntarily provides the keys to law enforcement on Herbert's behalf later the same day that there was an appointment that Herbert missed. Perhaps at the advice of his own counsel at the time. And what happens from there? Detective Pender starts ramping things up against Herbert. He obtains a warrant for Herbert's phone. He obtains a warrant for the ring cameras that are on the property. He is concentrating more and more on Herbert Swilley and Herbert Swilley alone as the primary suspect in this murder investigation. Totally oblivious to the fact that there was another person living in that home who was an adult who he needed to be investigating. And that person is Jordan Swilley. Who else would have had access to those vehicles other than my client? Was there any evidence presented that Jordan didn't have access to those vehicles? Rely on your own recollection, but I don't recall that. And is it not possible that that vehicle movement and activity was unrelated to the death of Tim Smith? Detective Pender did not get the cell phone data for Jordan Swilley until 8 months after he started his investigation of this case. By then, Jordan had gotten a new cell phone, and he was not able to retrieve the location data from her phone for the period of time in which Tim Smith was killed. And then there was an effort made to say, well, but I didn't do that because Jordan had a lawyer. Until the defense pointed out that, well, Sergeant Pender, you didn't learn Jordan had a lawyer until May the 30th, 2023, which was more than 2 months after Detective Pender's initial involvement. And a little bit more on this timeline and theory of the case. Is there any direct evidence showing that my client, Herbert, was at the apartment that the couple used for sex with others on either the evening of March 23rd, 2023, or the early morning hours of March 24, 2023? And the answer to that question is no. No one saw Herbert there during that date and time frame. Herbert was not captured on any video surveillance at or outside the apartment during that date and time range. There's no evidence placing him at that apartment during the period of time that the state claims, according to their theory of the case, that the body of Tim Smith was moved and placed there. How does one know that Tim Smith was even murdered at the marital home? How does one know that Tim Smith was given these drugs by the defendant? Sure, they have the statements that the defendant made to people that he thought were his friends, to people that he did work for, that he was unhappy, that he was having marital problems. That is what we call circumstantial evidence and or evidence of motive. But where is the direct evidence that he drugged his husband? Where is the direct evidence that he killed his husband at the marital home? It's not there. But there was direct evidence presented that James True is a violent guy. There was direct evidence presented that James True has used physical violence against another. There was evidence presented that James True threatened to kill another. Another thing that is rather interesting is that when they did that very detailed processing of the apartment, the victim, Tim Smith, had two phones. One was a red iPhone, that was the work phone, and the other was a Samsung Galaxy, which was his personal phone. There was a extraction, a Cellbrite extraction done on Tim Smith's personal phone, but there was no extraction done on the red iPhone, the work phone. And Jesse Newbanks, one of the state's witnesses in this case, he testified via Zoom on a previous occasion. There was a motion to perpetuate his testimony because he wasn't going to be available during this trial period. He's in training because he works for Homeland Security now. But they couldn't get into the iPhone to download the data because they couldn't unlock the iPhone. So we don't know what is or is not contained on that red iPhone. And we don't know whether or not Tim Smith was communicating with other people on that red iPhone. Because after all, Tim was going to be getting a new job very soon. Perhaps any concerns he might have had about using his work phone for personal reasons had gone down. Now I want to go back to Jordan. Jordan presents as a person who is stuck in an uncomfortable position, who is along for this unfortunate ride because of her ties to Tim Smith and to her father. But if you look at the evidence, what do you see? You see that Jordan, after her dad was charged with this crime, obtains a durable power of attorney for her father, a copy of which is in evidence, and she's empowered by that durable power of attorney to act as her dad's agent, to handle his monetary affairs, to buy and sell assets, motor vehicles, motorcycles, items that the defendant had. And because the defendant was charged with this crime, he was relying on his daughter to help him manage his affairs. And what does Jordan do, even though she has this fiduciary obligation to her father to act in his best interest? she sells off all the stuff and keeps most of the money for herself. She even sells the land that the marital home was located on without telling her father anything about it, without his permission or consent. She misrepresents to other people that this was a gift and that she would not receive any proceeds from the sale. But she testified that she did. She received cash from a realtor and she put it in her bank account. She claims she gave some monies to her father. Another interesting thing about Jordan is that Jordan is the second beneficiary of Tim Smith's life insurance policies with Hartford. Meaning, if the primary beneficiary, which is Herbert, is ruled out because of the Slayer statute, because it says a homicide, and because Herbert is accused of committing that homicide, then who's next in line? Jordan. So in addition to the monies she's acquired as her dad's power of attorney, she stands to gain even more if her father is convicted of murder. $333,000. Ladies and gentlemen, that is a motive to lie. That is an interest in the outcome of this proceeding. And some of Jordan's testimony against my client is rather damning. Particularly what she claims Herbert told her the morning of Friday, March 24th, 2023, when the two were talking about whether or not Jordan had heard any noises the night before, and what she claims her dad told her to say to lie for him. And the fact that she later would claim that she was with her dad when he dumped some prescription pill bottles at a convenience store trash can. Jordan has a motive to lie for her own financial gain. The state has introduced a wealth of evidence in this case. More than 70 exhibits. But it's not the quantity of the evidence that is presented. It's the quality. The video evidence, most of it, admittedly, is good quality. But it still doesn't tell us who's driving those vehicles. it still doesn't make the link to what, if anything, was in that white trunk, or what, if anything, was in that white Jeep. And we still don't know who it is walking by that Marathon gas station. And the quality of Jordan's testimony, where she states that my client made these statements to her, which would be indicative of involvement in Tim Smith's death, are not reliable. So, with these compilation of things, with these alternate suspects, with these persons who have their own motivations to bend the truth, what does all that come together to be? It comes together to be reasonable doubt. And Tim Smith was well loved, and his death was very tragic and unfortunate. And he was well supported then, he's well supported now. But this case is not to be decided upon sympathy for his death. It's to be decided upon the facts as determined by you, the jury, individually and collectively, and then applying those facts to the law from the jury instructions. And if you do that, and you still have a reasonable doubt, let's say you look at everything and you say, you know, if I could just look at the still photographs that Detective Pender claims that only he could see. If I still need to see that evidence, that's just one example of a reasonable doubt. Ladies and gentlemen, thank you again for your time and attention throughout this busy week. I ask that you return the only true and just verdict in this cause, and that is a verdict of not guilty. Thank you.
1 second, please. Does anyone need a break before we have Ms. Burns' final argument? Okay, Ms. Burns, you may proceed. Do you need the overhead projectors?
Yes, please.
Let me know when you're ready for them to actually go on.
Thank you. I'm not going to stand up here and rehash everything that I've already told you. I just want to address a few things that Mr. Klein talked about. What I gather from his closing argument is that this is the defense. James True did it. But if James True didn't do it, then it was Lloyd Kelly that did it. And if it wasn't Lloyd Kelly that did it, then it was Jordan Swilley. All of those things can't be true. And with Jordan Swilley, I'm not sure if the defense is she did the murder for some reason, or she's lying to get the money. Let's first talk about lying to get the money. If she was lying here so she could get the life insurance money, so her dad would get convicted, certainly she could make up a better story than what she said. How about just saying, hey, the Ring doorbell camera went off, I looked at it, and I saw my dad dragging Tim's body through the living room. That would do it, wouldn't it? I heard yelling. I heard screaming. I looked out the door. I saw my dad strangling Tim. I mean, you don't leave your common sense out the door. Use your common sense. If Jordan wanted to frame her dad so she could get the money, certainly she could say something better than, he told me to say I was home all night and that I didn't hear any noises. Now, he kept saying, who's driving? Who's driving the white truck? So I guess if Jordan's driving, then she's the murderer. Is where I guess we're going with that. So that means Jordan drugged Tim somehow. While Tim and her dad were sleeping in the bed, she somehow got Tim out of the bed or started beating him up, strangled him, moved his body, got it in the truck, and then drove it to the apartment and did all those things. Did that happen? Is that a reasonable doubt? I mean, none of that happened. She was 19 years old. She was devastated. And she lost a man she loved and considered a second father and her dad at the same time. And she couldn't support herself. She told you, I sold that stuff. I had the power of attorney. And she used the money to get an apartment. She currently lives in an apartment with her boyfriend and is a server at a restaurant in the Villages. That's where Jordan's at right now. And if she wanted to lie to convict her dad, she certainly could have had something that would put the nail in the coffin, but she didn't do that. And she didn't murder Tim. She had no reason to murder Tim. She loved Tim. She'd known Tim since she was 8 years old. There's been a lot made about why the white truck wasn't processed. Okay, say it was processed. Tim's DNA's in there. The defendant's DNA's in there. Tim and the defendant's blood's in there. Okay, it was their truck. That's not going to tell us anything. Don't be held up on what's in the white truck. We would expect everybody's DNA to be in there. Think about this. Where's that rug? Where's the missing rug? What was on that? We don't know because it's gone. We know that the defendant was certainly at the landfill right when it opened the next morning at 7. What was he doing there? And where's the rug? And why did he not tell anybody about that until a couple days later? He eventually told Sergeant Pender, but they were already talking to everybody, getting video footage, canvassing the neighborhood, because he did not tell anybody he went to the landfill when they first talked to him. Why didn't he tell anybody that, and where is the missing rug? And Tim's work phone. We talked about Tim's work phone. They couldn't get into it. They tried. The defendant himself said, we don't use that phone. They asked him, what's the number for Tim's work phone? And he said, I don't know. I don't talk to him on that phone. That's his work phone. So now the defense wants you to believe he's going to get a new job somewhere else, so I'm just going to start trying to pick up men on my work phone now. I'm just going to switch from my personal phone to my work phone because it doesn't matter. That makes no sense at all. And if Lloyd Kelly or James True did it, we have to remember they had to bring bleach with them too. Because there's no bleach in that house. The defendant brought the bleach. So those two masterminds got some bleach and then came up here somehow and murdered Tim. Now the last thing I want to talk about that's very important, it's been made a big deal about.
You ready for the thing?
Yeah. Yes, please. Is the still shots that Sergeant Pender saw on the defendant's phone. You just heard a lot about that. I want to just talk a few things about that. Remember that when the defendant handed his phone over to Sergeant Pender and they were both looking at the phone, the defendant had already accessed the Ring doorbell camera at 3:46 Friday morning. So he thought he had gotten rid of all of the video. He didn't realize that the still shots had been left on there. So he made that mistake. And remember, too, that by the time they got the search warrant for his phone and they looked for those, they had been deleted. So after Sergeant Pender looked at the phone and saw those, the defendant got his phone back. And then when they looked at it, he wised up, he deleted them. They were gone. Now what's important about this is the timing. And the defense says we were trying to make everything fit. Well, everything fits perfectly in the timing. Sergeant Pinder said, when he looks at the still shots, at 2:25 a.m., the defendant's truck was not there. 2:25 a.m. But then he said the next one was 2:28 a.m. And the truck was there. The defendant's truck was at their residence with a male figure. Sergeant Pinder wrote that in his report right when the investigation was happening. He wrote those times in his report. I saw at 2:25, no truck at the defendant's house. Then at 2:28, I saw a truck with a male figure. Later on, well after he wrote that in his report, we get the video from Pedro Vasquez. And guess what? At 2:27 is when the defendant's truck is passing by Pedro Vasquez's house, going back home. Which would mean the defendant's truck wasn't there at 2:25, like Detective Sergeant Pinder wrote in his report, but it would have been there at 2:28. I mean, the minutes of that, 2:25, 2:28 is what Sergeant Pinder writes in his report. We get the video, and at 2:27, that happens to be passing by Pedro Vasquez's house. There is no chance, it is not possible, and Sergeant Pinder's very smart, that he somehow figured that out and knew that that video was going to show that at 2:27. He wrote those times down in his report before we ever had this video. And it fits perfectly with what the deleted still shots from his Ring camera. $2:27, right here. Here comes the defendant. This is the defendant's truck coming back to his own house. He was not there at 2:25 when Detective Pinder said, I saw that still shot and the truck wasn't there. And there we go, pulling right into his house at 2:28. Exactly what Sergeant Pinder said he saw on the defendant's phone. It couldn't fit any more perfect than what you have right there. And that is why, ladies and gentlemen, the defendant is guilty of first-degree murder. Thank you.
Thank you. Ladies and gentlemen, if you can please listen carefully to your final instructions, okay? Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7. Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? 8. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? 9. Has the witness been convicted of a felony or misdemeanor involving dishonesty or false statement? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1. Whether, when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and has seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. Your verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. In this case, there's only one. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. It reads as follows. Verdict. We, the jury, find as follows as to count 1 of the charge. In parentheses, check only 1. A. The defendant is guilty of first-degree murder as charged in the indictment. Or B. The defendant is guilty of second-degree murder, a lesser included offense. Or C. the defendant is guilty of manslaughter, a lesser included offense. Or D, the defendant is not guilty. So say we all, dated, and this is the 19th day of September 2025, and it needs to be signed in pen by the foreperson. We will have a pen back there for you. Please do not sign the verdict in pencil, okay? In just a few moments, you'll be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way, and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you are agreed on a verdict, and bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror goes to the restroom, deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions, or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats, or they will be guarded by the court deputy while you deliberate. This now includes any sort of Apple or Google watch that can send or receive messages, okay? If you have an old school watch like me, you can keep it. If you need to communicate with me, send a note to the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items are received as evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. A. The exhibits will be sent into the jury room with you when you begin to deliberate. And B. If you wish to see an exhibit not sent to the jury room, and those are going to be videos which need to be played on the boards, please request that in writing. Everything else you will have, okay? In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There is no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we live by the Constitution and the law. No juror has the right to violate rules we all share. What I'm going to do is take the verdict forms I just read and put this sort of paperclip on them. And I have clipped to the back of these instructions the verdict form so it's easy to find. This packet will be used by the foreperson. It's the only packet that has a verdict in it, okay? I also have 11 copies of those instructions, and those will go to the 11 other jurors. I said 11 because only 12 of you are on the jury to deliberate. 2 of you have been serving as alternates, and the alternates will not go back to deliberate at this time. You'll be allowed to go home, okay? But I would ask that the alternates do not look up anything about this case until this evening, because if for some reason something happens to a juror, and hopefully nothing will happen, if that does happen, an alternate will be brought back in and the deliberations will have to start over, okay? So the 2 alternates are Douglas Parker, and if you can raise your hand when I read your name, Douglas Parker and Mark Cole. So for Mr. Parker and Mr. Cole, if you can remain here. First of all, let me say this. Have you left anything in the jury room? So don't remain here. Go get it out of the jury room real quick. And give your badges to the bailiff. The rest of you are not alternates. So. I never quite know when lunch is going to arrive, but I have not been notified that it's here yet. So we'll bring your lunch to you. So be expecting a knock on the door at some point, okay? And Mr. Cole and Mr. Parker, if you want to wait for lunches, you're free to do so. We'll be happy to give them to you. You can either eat them here or take them with you. If you'd like to leave, you're free to do that as well, okay? If you can both have a seat, and the other jurors at this point will go back into the jury room. This time you will take your notebooks with you. If you just have a seat real quick. Okay. First of all, I do want to thank you for taking your time to consider the case thus far. I also want to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in a jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work as a juror. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. Upon a request to discuss either your verdict or deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It's up to you to decide whether to preserve your privacy as a juror, okay? In other words, in no reason I don't want you to look up anything now, because in case something happens, but once the case is over, you are free to talk about it, but you're also free to never tell a soul about it. That is up to you individually, okay? I do have certificates for you. I do want to thank you for your service and wish you the very best, okay? If you could just exit out the door, but don't speak to anyone on the way out, okay? Mr. Cole, Mr. Parker, thank you very much, okay?
Thank you very much.
Carry it all.
Huh?
Carry all the stuff, so.
Okay. I don't know if they want to do lunch or not. They both kind of took off. We can check with them real quick before they go too far.
Probably don't.
We can check with them real quick, see if they want their lunches. But otherwise, I want both attorneys to check with the clerk as to what is going back with the jurors.
Yes, Judge.
And we'll be otherwise adjourned as soon as that takes place. Thank you very much. Everyone did a very good job. I appreciate it.
Judge. she already gave me all the other exhibits that we had. This is what exhibits by the
Just wanna make sure it's not really that one.
think the only thing I can answer on that is that the only information we have on his hospital visits are in the medical records that you have.
Yes.
There's no other records that are in evidence.
Yes.
Okay. 2, did they subpoena the dump? I don't know if that's in evidence or not.
It's not.
Just the videos and evidence.
Right. So there I'm going to say calls for information that's not in evidence.
Yes.
Whether they got those by subpoena or something else. Okay. 3, why did the detectives not run a plate report on Mr. Chua's car? Obviously, we can't answer that. So again, I'll say that, you know, because I don't think, well, I'll have to have them rely on their own, because I don't know, I don't recall them specifically being asked, why did you not run his wife's car? I don't think they were ever asked that specific question. He ran, I guess, the car associated with him. So that third question, I will probably answer that they'll have to rely on their own memory of the detective's testimony in regards to the cars. That's about all we can say on that. Anyone wants anything else said, let me know now.
No, Your Honor.
Okay.
Yeah.
All right, and then we'll play the videos. Okay, let's bring them out.
Judge, if we could test this first to make sure it's working
Sure,
with the
I'll
sound
bring
and
them out.
everything. Thank you.
The body cam hunt and landfill videos.
No, you're good. You haven't had this time.
Glad I asked.
No problem.
For some reason, it's stuck on that. I don't know why. Can you disconnect and reconnect this, Judge?
This only mirrors what's on your computer. It doesn't have
But it's
anything.
not. That's the problem.
Okay.
It looks like it's caught from what was still in closing.
Okay. All right, there you go.
No, it's not duplicating the image again for some reason.
Is that the body cam there?
Yes, sir.
And there's another one.
I have both.
That's the landfill. Okay.
It's the landfill.
All right. Looks like you got it. I'm just going to take it off the screen for whenever you're ready, so I can answer the questions. that the correct one?
We called in.
Let's go back to where it says, well, I'm just gonna take it off there right now. So you're not looking at it when, but it should go right back on when I put it on.
It should.
In saying that, let me be sure. Okay, I'm gonna read from what I've put on myself, jury note number 1. Go ahead. Bring it back, thank you. All right, members of the jury, I have discussed your note with the attorneys. You have asked the following, and I'm going to read it, okay? And I've labeled it jury note number 1. We would like to see body cam dash hunt landfill videos. Questions. 1. Any information on Tim's previous visits to hospital? And then another part of that. Did they have any drug panels ran for OTC drugs? 2. Did they subpoena the dump? 3. Why did the detectives not run a plate report on Mr. True's wife's car? If I've not read this question correctly, please raise your hand. Okay. What I'm going to do is we'll show you the videos that you've requested. You can watch them as many times as you like. You can move if you want to get closer to the screen if you want. Just let me know. But before we do that, I'm going to try to answer your questions to the extent I'm legally able to. We're a court of law, so we follow rules, so I can only do what I'm legally able to do. The first question, which looks like it has a couple different parts to it, any information on Tim's previous visits to hospital? Did they have any drug panels ran for over-the-counter drugs? The only way I can answer that is that all the medical information that is contained in evidence is in the medical records that we have already given to you. There is no other information available on that in evidence. 2, did they subpoena the dump? The answer to that question is not in evidence, so I cannot answer it for you. Your decision must be based only on the evidence presented in the trial in the law that I have given to you. 3, why did the detectives not run a plate report on Mr. True's wife's car? Ladies and gentlemen, it will be up to you to use your recollection as to what the detective testified about regarding Mr. True's vehicle. Please play the body cam of Hunt.
We called in because my other half haven't seen since late Thursday night when we went to bed. He didn't show up for work yesterday. They've called, they've texted. Everybody's called and
Pause.
texted. We don't actually live here. This is his...
Pause. Sorry.
Is there anything at certain points in the video that we can ask that pause the video?
Yes, sir. Thank you. What I would say is if you want to pause, please raise your hand. Now, none of us are IT experts, so we'll try to get back. But you can, if we pause in the wrong place, just let us know. You can watch as many times as you want. Okay? Do you want to go forward from here?
Yeah, what we're looking for is just a closer image of his.
Well, hold on. Just let me raise your hand when you say pause. Okay? Okay, thank you. And don't tell me why you want to pause there. Just say pause.
Can you remove the display for a second, Your Honor,
Yeah,
please?
that's fine. We're having problems with the display. It shouldn't even be on there. You ready?
Okay, Your Honor.
We called in because my other half haven't
Pause,
seen
pause.
since late Thursday.
Pause. Do you want us to go back? You want to leave it there or you want to go back a little bit?
Get there. Can we see it closer?
You want it expanded?
Yes, please.
Okay. I say just go to slideshow from the beginning. Can you do that? I think the problem is it's on here, it's smaller, that's not taking up the whole TV.
I understand the problem is I can't pause it through that display mode. Can you take it off for 1 second again, Judge? Let me try
that's
something.
fine.
Changing the display mode, Your Honor, to see if I can get it to pause while it's playing.
It's okay. Unfortunately, we can't use the software engineer to get that done. Do you want me to call the IT department to assist you?
Can you just give me 1 second, Your Honor? I
Sure.
apologize.
That's okay.
Judge, if we could watch the landfill video first, what's happening is when I play it and I try to pause it, it advances just to the next slide. I can't pause it internally with this method.
Okay.
What I can do is I can get an external drive, take the disk in evidence, and pause and play it and pause it that way.
Okay. All right. So
But we can start if you want to start with the landfill video.
we'll start with the landfill video, and apparently you can still go and get a drive. Let me know when you're ready.
Yes, sir.
But we can also, if you want, I can play it straight through. Why don't we do that too? You want to just play it through? Let's start with the landfill one, and then we'll play that straight through depending on when she gets back. Okay.
Yes, sir.
The landfill one's not on.
Okay.
Pause.
Can we see that part again as it starts to take off?
Yeah, let's just, yeah, okay, we can play it again. If you want to stand closer, you can. And you can also stand close to that screen right there. That's actually ground level. If you want. Well, we got the other half. There's still more of it. Here's the other part.
Your Honor, if you could take it off of presenter view, I can then play the body cam. Thank you. Okay, Your Honor.
It's off. Somehow it's sticking.
Judge, there was a hand raised from the jury.
Yeah, I'm trying to deal with this first, but yes.
Yes, Your Honor.
Yes,
Could I
sir.
submit a question to you
In writing.
in writing?
Has to be in writing. Put it back on. For some reason it's sticking. The image is sticking.
You called in because my other half I haven't seen since
Pause.
late Thursday night when we went to bed.
I tried it earlier.
Do you want to pause very early in, is that correct? Okay. Jurors indicate they want to pause very early into the video.
Of course, this computer does not have the same port as the other one. I apologize, Your Honor. If we could take it off of display mode, Judge. Thank you. Okay, Your Honor, I think this hopefully will work.
Please pause it just a few seconds into it. Got no sound.
Because I had my sound turned off during court, Your Honor.
Called in because my other half.
Okay, stop. Go.
Since late Thursday night when we went to bed. He didn't show up for work yesterday. They've called, they've texted. Everybody's called and texted. We don't actually live here. This is his secondary apartment that he uses for his massage studio and other stuff. But his Jeep's been here, the girl's now saying, for almost 2 to 3 days. It hasn't moved, and we can't get a hold of him. We've called, y'all did a wellness check yesterday. They couldn't go in because I don't have a key, so they told me to get a hold of the landlord. He actually has a key. Okay. But they told us not to go in since I'm not legally on the lease or anything.
Okay.
So.
What's his name?
Timothy Floyd Smith. But it's not like him because normally he's the executive director at the Brookdale Shambrel Prank Castle, so he's very responsible about it. You know, that's his job. He does everything.
631.
Okay, 631.
And that's his wife.
Go ahead and start medics this way. Yeah. What is it, C?
Yep. Yeah.
Perfect. Sheriff's.
Yes, sir. Want to pause?
Yeah, could we skip to when they communicate again after the officer instead of
Just when the officer comes out. Okay. It's an imprecise process, but I think I'll have to.
Cancel medics. Signal 7.
10-4, signal 7.
He's in there, he's not okay?
Yeah.
Sorry, Lord. Well, they would have been here last night if I hadn't given out the wrong phone number. I didn't give them Jack's phone number for the landlord because I have it in as Jack in Ocala with an L. So I thought it was Jack for landlord, and it's Jack of AA that we saw at our retreat. And I gave him that number, and he called me this morning and said, Herbie, I'm not Jack's landlord, so why are you calling me? And I'm like, oh my God, I said. So I've been scrolling through it. It took me 45 minutes to find his number, and I had to find it via text. I've got to call Kevin. Kevin's the only.
When's the last time you saw him?
I went to bed on Thursday night, and I go to bed about 9:30. He finishes doing his medication. I would say about 11 I heard him get up, but that's not uncommon because he gets up and he'll go do Facebook posting for this stuff called Thrive, and he'll just relax and stuff, but I assumed he was still home, to be honest with you. I got up my regular time, 4:40. I went straight to the gym like I normally do, the Planet Fitness. I came home very quietly because if he's asleep, I try not to wake him because he doesn't have to be to work until 8 or 9. So I went in, took my shower. I left with my work trailer to go to work. I got back because I picked up all the materials, and before I went to the villages, I figured I'd stop back by the house because I had forgot to get a change of clothes. So I stopped back by the house real quick. I went in. The bed was unmade. He wasn't in the
You're
house.
saying stop by the house, not here.
No, my house, because we
Where's
don't live
that at?
here. We live at 5388 Southeast 26th Court is our physical house. This is just his
Gotcha.
massage office, our playroom and stuff like that, because that's what this was set up for, so that way we could host parties occasionally, because we have a 20-year-old daughter and he didn't want to do it at home. And so when I went home, this was out of the garage on Thursday morning before 8. This was not there, so I don't know when he left. And he wasn't there. So I went on to work, and at 4 o'clock yesterday afternoon, I got a phone call from Tammy Warner at Brookdale and said that they have not seen Tim or heard from him. They've been texting all day. So that's when I told her about the apartment.
What time was that?
That was at around 4.
PM?
Yeah. So then I drove over here. I saw the Jeep here, so I knocked on the door and everything. And no answer, no nothing. I called the sheriff's department, and they told me not to go in since I'm not on the lease. So I went on and did that.
What? 4 o'clock. I'm interrupting you. 4 o'clock yesterday?
Yeah.
Okay.
Yes,
And
sir.
you haven't seen him since Thursday?
Well, since I went to bed, because once I go to
Right.
sleep, I don't hear anything because I take a couple of sleeping pills and
Gotcha.
stuff because,
So Thursday he was at the house on 26th Court.
yep,
Thursday morning.
he was not. Because when I went back there, it was,
You mean Friday morning?
well, yeah, Friday morning,
Okay.
yeah. Getting
Okay.
confused because just kind of, yeah, Friday morning,
Okay.
which would have been yesterday morning. And
Well-
then this morning I've texted him several times. We've had everybody calling and texting him all day and everything.
What kind of? He usually has his phone. What kind of phone is it?
He has the same phone I do, except for the case is clear. It's a Samsung. And he also has a work phone. That I don't know the number to because that's a Brookdale phone. That's,
What's his phone number?
It's 352-283-2372.
Do you have his? You don't have his work number?
No, Tammy Warner is going to come by, so she would have it. I don't. He's never. That's something that we don't call on his work phone because it's a drug deal phone, and everything I'd call for would be personal. So that's just the way we've always been for 15,
all I have. What was
15 years.
What was your name?
I'm Herbert, H-E-R-B-E-R-T. Swilley, S-W-I-L-L-E-Y.
What's your birthday?
It's 02/02/1968. We are legally married.
What's your phone number?
352-283-2372.
And what was your name?
Jack Sharfsworth. It's 14 letters. S-C-H-A-R-F, S-C-H again, W-E-R-D-T.
What's your birthday?
8/11/63.
And you don't live here. You're just a landlord.
Yeah, I own it, but yeah, I live across town.
Okay. What's a good address for you?
My home address?
Yeah.
4041.
These little pads are so hard to write on. All right. So our major crimes detectives will probably have to come out and take over the investigation. Standard procedures.
Stay out here then.
Yeah, they're going to need to talk to you. They're going to ask you pretty much the same questions I asked, but they might ask a few more.
I know. My dad's a retired deputy sheriff from Washington County. So
Okay.
yeah, that's how come I knew that I had to do certain steps because I had done it once where I had a tenant that was mine, and I went into the apartment, and I almost ended up in jail for because they weren't there.
Yeah.
And I ended up having to go in. They found out, and it's like it's just it's a very tough area to be in.
Yeah, I'll be hanging out until they get here. So if you have any questions or anything,
I'll just stay here. Then I'm going to call I'm going to call my sponsor and stuff.
Okay.
He's my best friend too.
Okay. But we have our advocates that are available if you need someone to talk to about resources that are available and everything. I can have one of them come out and talk to you if you'd like.
That's fine. Yeah,
Okay.
definitely. Because this will be difficult. 'Cause
Yeah.
we have a daughter too, and
I got you. Yeah.
so
I'm gonna pull my car up right.
that's fine. That's why I pulled over there, and I didn't bring my truck. I knew it'd be.
Yeah.
I have a trailer and everything.
Oh, okay.
You wouldn't want to watch it again? No? So you return, your lunch is here now, so we'll give you your lunch and we'll go from there, okay?
There are 2 body cams. The jury doesn't want to see the second one.
What's the second one from which?
The same deputy?
Yes, it was.
Apparently there's 2 of them. Do you want to watch both?
I want to see this.
Okay, well, we'll play the other one. They're both in evidence?
Yes, sir.
This place, is that why you didn't have a key?
This is not a primary residence.
No, I mean.
No,
His-
I have a key, but my daughter thinks he took it off the key ring at the beginning of the week because when he goes and plays, he wants the key, so that way he's not over here using it. So I have a key, but I think it's with his stuff here.
Okay.
Because when he goes and plays during the week, he takes the key
Gotcha.
because he doesn't want me interrupting. And his thing to me tells me I'm doing a massage. So I know what it means, and I let it go, and, you know. At least the daughter thinks he may have taken the key off the key ring. Otherwise, I lost them because they're supposed to be on a key ring like this. Yeah, it's supposed to be on this, and this piece is not in my key. So this whole assembly on my other truck key, this is gone with my 2 keys. So, but she doesn't know for sure. She just thinks he may have gotten it, or I may have lost it.
If there's 3 of them missing,
Yeah, but took the whole assembly. And that would have been That'd have been like Tuesday. Because we don't use keys for the house. We have digital remotes for everything. And we have power gate openers and stuff, so I wouldn't even know where to look for my house key to find it. Somewhere in one of the drawers, I do know that. Because that's what we've done with them.
How often does he come over here, and does he stay the night?
No.
Never
That's
stays the night?
He never stays the night. Well, he's only stayed 2 nights that I know of. That's it.
How long? Like,
2 nights one was a couple of weeks ago, and then one was right after we finished the place. He stayed 1 night that I know of.
so in the last month, he stayed 2 nights?
Yeah. I'd say in the last month easily. But he never leaves like very many clothes here. He only leaves the
What was he wearing last time you saw him?
a pair of blue jeans. I don't remember the shirt. I know it's an Affliction shirt probably. It's either that or an American Eagle, I can't remember. And he usually wears either boots or hay boots. And since it was in the evening, I knew he'd be getting ready for bed, so he'd be changing into something else. But then at that point, he would wear like fitness type pants at night to sleep in, and just a t-shirt. But when he walks around the house and everything, anywhere he walks, he won't walk barefooted.
Do you know of anyone else that came over here?
I don't know who they are when he brings anybody over or anything like that. They're all on his either Adam for Adam account or his Grinder, Growler, stuff like that is what he uses. Same thing I have. I was over here last Saturday with somebody that I know, and he didn't want to play or anything, so Tim went and did a motorcycle ride. So I was over here last Saturday, and that's how when I knew I had my key, because I was over here last Saturday during the day.
What's, is it his daughter?
It's my daughter.
Your daughter? What's her name? Does she live with y'all?
Yes.
What's her name?
Jordan, Jordan, Swilley, Swilley.
What's her birthday?
May 11th. And she should be right now. I'm not sure how many hours she's working at her new job.
Yes.
No, she quit Laredo. She got tired of Laredo's because somebody offered her some marijuana and some pot and stuff, and she just was tired of all that drama in her restaurant because she doesn't.
And you said he didn't use anything?
No, we both quit drinking and stuff. Like I said, I've got 3 years, January 5th. He's got it August 13th. Would have been 3 years.
Okay.
I mean, so it's past 3 years now. Yeah, because it was the 2019 in August when he decided to quit drinking, and then I quit after that.
Okay.
Because we were drinking way too much.
I got you. Is the keys to the Jeep on a lanyard or anything?
They're usually in a black bag that he keeps on his shoulder, and it just goes in there because it works on a fob. He doesn't keep them in his pocket.
Okay. So he just holds the bag and pushes the button.
Well, he holds the bag and he just touches it, and
Yeah.
I can tell you now, he won't even keep a key in his pocket hardly at all. He barely keeps them at work in his pocket. He puts them down on the desk. That's one of the things that always bugged me. It's like, when we go places, you can carry your key.
Yeah.
I know. You can carry the black bag. Always has a black bag that has everything in it.
Okay.
And I know for a fact his gun is not in the black bag because it's sitting on the dresser at the house.
Okay.
That I know for a fact.
Alrighty.
me and the daughter came over, knocked on the door last night. I took that gun out because that was my gun.
So the Jeep was unlocked?
No, the Jeep was locked. I came last night with my key. I have a set of keys at home for it.
Gotcha.
I just didn't bring them now because
Yeah.
I didn't think about it. But we came last night just because Candy made a point to me, not you. Friend Candy said, she says, do you have a gun in the Jeep or anything? I said, yeah. She said, well, you shouldn't leave it there unsecured because it's in your name. So we came by last night. We even beat on the door after the officer just to see if we could get a hold of him one more time. And he got nothing. But I put that gun on the dining room table just so it wasn't here.
What time were y'all here?
It was probably around 9-ish.
Okay.
Or actually, it had to be before 9. Because I know we got back home just before 9.
Okay.
So I can probably kind of give you a better time.
No, that's fine. I just approximate. That's fine.
Sometimes I know where I was at and who I was calling at the time. Is how
Oh, I get you. No, that's fine.
Thank you. Begin deliberations again. All right, we'll be adjourned. Is there something else? Attorney's on the way back, or?
I don't know, Your Honor.
Okay. Have they been notified? All right, ladies and gentlemen, it's my understanding the jury has reached a verdict. When they come in, we'll have that verdict published by the clerk. Again, I want to remind everyone to stay completely quiet, okay? We're going to all stay completely quiet regardless of the verdict until court is adjourned and everyone has left the court. And then you're free to do whatever you want, okay? But in the courtroom, we all stay quiet. Let's bring the jurors back, please. Thank you. Ladies and gentlemen, it's my understanding you've reached a verdict. Is that correct?
Yes, sir.
I'm going to have the foreperson hand that to the bailiff. Thank you. All right, I'll have the clerk publish the verdict.
Verdict. We, the jury, find as follows as to count one of the charge. The defendant is guilty of first-degree murder as charged in the indictment. So say we all do this 19th day of September 2025.
You decide want the jurors polled.
Yes, Your Honor, please.
Madam Clerk, please poll the jurors.
Billy Butler, is this your verdict?
Yes.
Andrea Thayer, is this your verdict?
Yes.
Hester Hill, is this your verdict?
Yes.
Trent Mansell, is this your verdict?
Yes.
Kimberly Fry, is this your verdict?
Yes.
Robert Speck, is this your verdict?
Yes.
Erica Fleck, is this your verdict?
Yes.
Andreu Garcia, is this your verdict?
Yes.
Christopher Myers, is this your verdict?
Yes.
Michael Donaldson, is this your verdict?
Yes.
Kelly Cribb, is this your verdict?
Yes.
Catherine Natal Martinez, is this your verdict?
Yes.
Ladies and gentlemen, I wish to thank you for your time and consideration in this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. That, ladies and gentlemen, I'm going to ask you to go back to the jury room, and I'll discharge you in just a few moments, okay? The bailiff has your phones and all the other electronic devices. All right, Mr. Swilley, the jury has convicted you as charged of murder in the first degree. What do you want to do about sentencing? Just there's really no real choice in sentencing.
There's no choice. I don't know if the state has any victim impact statements or needs.
Well, I was going to address that with them in a second.
Prepare same, but we're prepared to go ahead with it now. If that's okay.
What
with
is
the
this?
state.
What is this?
Judge,
What
we
does the state want
would
to do?
like to go ahead with sentencing now, if I could just have a minute to
Well,
see
I'm
if
going
anybody
to
wants.
discharge them,
Okay.
but I certainly, whoever has a right to speak,
Yes,
will be
Your
given an opportunity to speak. But I didn't know if they were here or not. So,
I believe everybody that would want to speak is here, but if I may have a moment to check while
Sure.
Your Honor goes back with the.
Sure. So we'll be adjourned just for a few moments, okay? go back on the record. We're here on 23 CF 4461. Here for sentencing on Herbert Swilley. Ms. Byrne, is there any witnesses you want to call or anyone who wants to make a statement?
Yes, Your Honor, we have 3 people that would like to make a statement.
Go ahead.
First person is Valerie Smith.
Yes, sir. Thank you.
Your Honor,
Come on. Good afternoon, ma'am. Before you say anything, can I have your name, please?
Valerie Smith.
Yes, ma'am. Go ahead.
It's hard to put a lifetime of love and memories into one piece of paper. But I didn't come here prepared to do this, or I probably would have brought a book. I'm Valerie Smith, Tim and Sandy's cousin. There's a few of us here, and the other dozen or so are live streaming. I'm here to speak on Tim's behalf because he can no longer speak for himself. I feel qualified because the 3 of us were always together growing up. Their dad and our dad were brothers and the best of friends. So every chance we got, we were running through the woods of Dixie County together. And later in life, I always looked forward to family gatherings because I knew Tim would be there. He never missed one. The day that we learned of his death, we were all together waiting on him to get there. We weren't sure if we should eat or go ahead to eat without him because we knew Tim was coming. But he did not. And he never will again. When he entered a room, the joy level would immediately rise. When you would talk to Tim, you and he were the only people in the room. He was like that with everyone. He was so many things to so many people. You knew you were important to him. On his wedding day, I tried to let him know how important he is to me. I told him that his bravery and courage to live an open and honest life had led to me finally being able to do the same. We were the same age, pretty much, but I looked up to him, and I love him so dearly. We will miss him every day until we see him again. I love you, Tim.
Thank you very much, ma'am.
Blake Riles.
Sir, if you give us your name.
Yes, sir. Blake Rouse, Your Honor. I'm the defendant's nephew. Or not defendant, well, I guess you could say that too. But Tim really meant a lot to us, and I just want to say having him gone it's been hard on all of us, and I want to thank the state and everything that everybody's done and all that's went on this week. It's been so hard on all of us, and I'm glad we finally get to lay Buddy's memories to rest. I just hope that I may not forgive what happened, but I hope you can find forgiveness yourself. That's all I have to say on the situation of this, and I think I'm done.
Thank you very much, sir.
Candace Baker.
And if you could put your name on the record, please.
My name is Candace Baker. Tim was one of my best friends for 4 years. Very short, but very impactful time. Tim was an amazing, smart, loving person, and a lot of times I wish I was more like him. He was intelligent, kind and loving to all types of people. And there wasn't a selfish bone in his body. And he was a giving, and he made everyone feel heard and special. And this tragedy and losing Tim has made me question my ability to trust people and believe in people, because I love people, and now I wonder if people are honest and good, and I refuse to let that side win. I'm so honored to have spent those 4 years with Tim, and I'm so grateful for this court and the system for giving us justice. Thank you.
Thank you, ma'am.
That's all the state has, Your Honor.
Ms. Byrne, is there anything you want to add for sentencing?
No, Your Honor.
Okay. I have, the credit is 686 days between November 3rd, 2023 and September 19th. I get you add 687. It's 686 plus 1, 687. I know. Mr. Klein, anything you want to present for sentencing?
Your Honor, I have advised my client of his right to speak. He has advised he does not wish to make a statement or speak to the court, so we do not have anything to present from it.
Is that correct, Mr. Swilley? You don't want to make any sort of statement?
Yes.
All right, I will not hold that against you anyway. However, much of the sentence here is required by statute. In this case, you're going to be adjudicated guilty of murder in the first degree and sentenced to life imprisonment. There is a, I don't know if you do, you have to pay court costs, and then you'll have to pay $100 cost of prosecution. Let me go back. Is the state requesting the $100 cost of prosecution?
Yes, Your Honor.
All right. Based on the state's request, I will grant the $100 cost of prosecution. Anything else from the defense?
No, Your Honor.
All right. And you have 687 days credit. Anything else I can miss? Good luck to you, sir. You have 30 days to appeal. Do you want to have an attorney appointed for purposes of appeal?
Yes, sir.
Okay. You'll need to talk to your attorney about that. Do you believe you can, were you appointed or hired?
I was hired, Judge.
Okay.
I met with him in the back. I had him complete an application, so I will prepare the notice of appeal related documents, and then I will be moving to withdraw and asking the court to appoint a public defender.
Ms. Willie, I want you to raise your right hand. Do you swear or affirm the information you shall give us the whole truth and nothing but the truth, so help you
Yes,
God?
I do.
Can you afford to hire an attorney for purposes of appeal?
No, sir.
I take it you have no income at this time?
Yes, sir.
All right. And I take it the house was sold and gone?
I don't know.
Okay.
Ceiling's gone.
All right. I'll appoint the public defender for purposes of appeal. All right. Good luck to you, sir. You have 30 days to file an appeal. We'll be adjourned.